In the Michael Jackson trial, both the defense and prosecutors are in a California courtroom right now questioning potential jurors. But documents questioning the accuser's credibility have been uncovered and could be a factor once the trial gets underway. NBC's Mike Taibbi joins us live from the Santa Maria courthouse with the details. Hi, Mike.
Well, Lisa, how are you? The sexual molestation part of the case against Michael Jackson is, as has been reported, going to rest almost entirely on the credibility of the accuser and the accuser's brother, sister, and mother. But we have learned exclusively that a past allegation of abuse in the home made by the boy was later found to be unfounded, and that other abuse claims by the boy and by other members of his family were simply never pursued. In March of 1996, when Jackson's accuser was 7 years old, the boy became sick at school, but before his mother could be called, according to the father's lawyer,
the boy broke down and started crying and saying, I don't want you to call my mother because she'll beat me, she'll hit me.
Documents obtained exclusively by NBC News show an investigation was begun by the Department of Children and Family Services into alleged abuse of the boy by his parents. But the boy changed his story, and the allegation was declared unfounded.
The same boy denied any hitting by the parents.
4 years later, in 2000, as NBC News was first to report, the accuser's mother belatedly added on a charge that she'd not just been beaten, but had been sexually abused by a JCPenney security guard after a shoplifting incident that led to a lawsuit. The children backed her story in what a defense psychiatrist called clearly rehearsed testimony, but the sex abuse charge was never mentioned in an amended complaint or in the settlement JCPenney's offered without admitting any wrongdoing.
She just came up with this fairy tale, not a fairy tale, it's a horror story, and just ran with it.
Then the next year, 2001, police responded to an ugly argument that spilled into the street during the parents' bitter divorce. At first, Jackson's accuser and his siblings told the social worker they'd witnessed no hitting, just yelling by their father over the years, and not a lot of yelling. During this interview, the mother was away at work.
She was angered by the fact that they came out and spoke to her children without her being there.
But days later, with their mother present, the boy and his siblings changed that story. Now it was daily beatings of all family members, punching, kicking, breaking bones, holding the mother's head underwater, constant threats to kill them all. The mother added weeks later that she'd observed the father inappropriately touching the couple's daughter when the daughter was much younger. A domestic abuse expert says the delay in making the sex abuse charge doesn't diminish its believability.
It's actually quite typical for sexual abuse either of the adult or of the child to be reported much later.
But the father's attorney says he never heard one word about the sex abuse allegation from anyone. He was never charged.
Never charged, and I guess that it got as much attention from the prosecutors as we gave it. It was just a rant on her part. It was patently untrue.
In the end, Halpern advised the father to plead no contest to one charge of spousal abuse and one charge of cruelty to a child in exchange for a sentence of probation, no jail time, despite the dramatic allegations against him of sex abuse and physical brutality. An order of protection that is still in force bars the father from being in contact with his kids. He is seeking to vacate that order and also to expunge the two no-contest pleas that he entered to the charges which a court affirmed were supported by evidence. The charges of spousal abuse on the one hand and one count of willful cruelty to a child. The convictions still stand. In the meantime, the prosecution continues to press its motion to bar or limit all evidence from prior litigation involving this accuser's family, claiming it would be prejudicial or misleading or confusing to a jury. The defense, on the other hand, insists it would be precisely relevant. Lisa?
This is going to get interesting. NBC's Mike Taibbi. Thanks, Mike.